So if someone presented you with a check and let's say subsequently the check is dishonored, uh, then there are certain criterias or legal ingredients. If those criterias are met, then only an offense can be taken and a complaint can be filed before police or other competent authority. And there is a one popular or particular judgment which outlines those criterias or ingredients. Some of them are de facto, but there is one that is very crucial. So the judgment is Jugesh Sehgal versus Shamsher Singh Yogi 2009, 14 SSC 683. One other thing you must know that under Negotiable Instrument Act, Section 138 talks about offense under Negotiable Instrument Act, which is the main, and that's why most of the cases get lodged, which is Section 138. And this section is only invoked when the check is dishonored due to insufficient balance. And if your check has been dishonored for some other reason that may not be may or may not be uh, considered as an offense, but if it happens only due to balance, then only a criminal case can be lodged. So here are those six specific ingredients or the criterias that have to be met. Number one, it says a person must have drawn a check. As I said, that is the de facto. You must have a valid check. Second, check must have been should have been issued, which is again a de facto status. Check has been presented to the bank, again a de facto status, because that's how check is dishonored or it is encashed. The check is returned by the bank unpaid either because of the amount of money standing to the credit of the account is insufficient to honor the check or that exceeds the amount. So this is where the balance or the amount is concerned. So if the sufficient or the required amount is not there for whatever the reason, uh, then only a complaint case can be made out under 138. Now, this criteria number five is the most important one because if this particular criteria is not met, then you cannot make a criminal complaint. Or even if you make a criminal complaint subsequently, that complaint might get quashed or it will, any order might get set aside. So it says the payee means whoever is holding the check makes a demand for the payment. So what happens in this case is that if you are with the check, your check gets dishonored, you basically write a formal letter letting him know that your check has been dishonored, so please make the payment within 15 days of receipt of this notice. And that is what it says: within 15 days receipt of the information by him from the bank regarding the return of the check as unpaid. Then the drawer of such check fails to make payment, which is the last one. So despite having received the notice, if the drawer does not make the payment, then only within again 15 days of the receipt of the said notice. So after 15 days, once the drawer receives the notification or the receipt or the letter, whatever, this might also be via email if that is a mode of communication between uh, the drawer and the payee. So in that case, after 15 days only, a criminal complaint can be lodged or can be made. And this is the judgment. Thank you.